Welcome to the Supreme Court of the United Kingdom, where today we are hearing in the Privy Council, I should have said, in the Judicial Committee of the Privy Council, on appeal from the Court of Appeal of Bermuda. We're hearing the appeal in the case of the Attorney General for Bermuda and Ferguson and others. The issue in the case, put very briefly, is whether legislation in Bermuda, providing that only marriages between a man and a woman will be recognized, infringes the Bermudan Constitution. I'm hearing this appeal with four colleagues: Lord Hodge.
Good morning.
Lady Arden.
Good morning.
Lord Sales.
Good morning.
And Dame Victoria Shaw.
Good morning.
The appellant, the Attorney General, is represented by Jonathan Crowe, Queen's Counsel, and Tom Cross, and the respondents are represented by Lord Pennick, Queen's Counsel, Rod Attrai-Sterling, and Sean Dunleavy. I'll now invite Mr. Crowe to begin the submissions on behalf of the Attorney General.
Thank you. May it please you, my lady, my lords, as you will be aware, there are essentially three main topics to be covered in the appeal. The first is whether or not there is what has been, for short, described as a religious purpose rule, that legislation cannot be made consistently with Bermuda's constitution if it has wholly or mainly a religious purpose. The second broad issue is whether or not there is any hindrance to the enjoyment of the freedom of conscience under Section 8 of Bermuda's constitution. And the third main topic is whether or not there is discrimination contrary to Section 12 of Bermuda's constitution. We will be addressing you on those three topics in that order. We won't repeat everything that is said in writing, and we may not even cover all the topics that are covered in writing, not because any of the points are unimportant or because they are being withdrawn, but simply because in the interests of time, it's obviously desirable to concentrate on those issues which need to be emphasized and expanded orally. With that, could I just, before turning to the religious purpose rule, just remind you of a couple of the background facts, starting with a very brief chronology, which you already have in mind, but I think it may help just to be reminded of a couple of features of the factual background. Exactly how they feed into the legal argument will come up in about 2.5 hours, but I just wanted to fix the factual context a little bit by reference to some of the documents. And if we could just start in February 2016 with a press release by the administration that preceded the administration in Bermuda, which promoted the legislation with which we are concerned. And if I could, I don't know if any of you, my ladies or my lord, are actually using hard copy bundles, or whether I can just give the electronic bundle reference.
We're all using electronic bundles only, Mr. Crowe.
I'm grateful. In that case, if I could invite your attention to page 1229. You'll see that this is a press release from the then Premier of the One Bermuda Alliance, which, as I say, was the preceding administration. And under the photograph, and after the good morning, it recites that, as you're aware, the Minister of Community, Culture and Sport tabled a draft Civil Union Bill 2016 for consultation in the House of Assembly. The aim of tabling the draft legislation is so that we can have the widest possible discussion and consultation on this matter, not just with our parliamentary colleagues on both sides of the aisle, but with the broader public. You also heard the Minister highlight that the issue of same-sex marriage and civil unions is at the forefront of our national conversation. And it then goes on, if you turn over to page 1230, there are some bullet points. A series of public information sessions is being proposed, sharing of extensive research, outlining Bermuda's international responsibility, the proposed way the Bermuda government would implement and manage civil unions, and meeting with advocacy groups and individuals. And then 2 paragraphs below that, as such, the government has an obligation to bring the matter of same-sex unions to a resolution, and in order to get the widest possible reach of views from the people, it is the intention of this government to table a referendum bill on the matter in this legislative session. And I won't read on, but the whole of that provides, I think, in a sense, a useful starting point for the public consultation debate. That was then followed, as you will have seen from the Statement of Facts and Issues, by the Referendum Act in March 2016, which was followed by the referendum in June 2016. Slightly less than 50% of the population voted. I think it's about 46, 47%. And so the resolution was, the referendum was regarded as not being conclusive. But of those who voted, it is a matter of record that 69% were against same-sex marriage and 63% were against any form of legal recognition of same-sex unions. Time passes. May 2017, a court decision is issued, first instance, in the case of Godwin and DeRoche, and you will have seen reference to that. And the essential thrust of the decision is that the registration or not of marriages by the registrar constituted the provision of services under Section 5 of the Human Rights Act, and the registrar was therefore acting in a manner which was discriminatory on the grounds of sexual orientation by refusing to register same-sex marriages. So now, by that judicial decision...
Mr. Crowe, I'm sorry to interrupt you. It looks as though we have lost Dame Victoria Sharp. I'm afraid we're going to have to adjourn until we reconnect her. So I'm sorry, I'll have to stop you there. We'll simply mute ourselves and stop the video stream while the problem is sorted out.
Okay. I'm sorry, having said that, I see...
She's now rejoined us. I wonder, Dame Victoria, how much you missed there. I wonder at what point you left us.
I left you 2 minutes ago.
We were going through the chronology, and
you're just dealing with the press release.
Right. So you'd left us before we got on to the Referendum Act in March of 2016.
Yes.
Right. Mr. Crowe, perhaps you could resume there.
Thank you. So briefly to recap, there was legislation passed in order to enable a referendum to be held, and the referendum was held in June of 2016. And although less than 50% of the population voted, of those who voted, a majority voted against same-sex marriage, and a slightly smaller majority voted against any form of legal recognition of same-sex unions. That was then followed by a judicial decision in the case of Godwin and DeRoche in May 2017, under which the first instance court in Bermuda decided that the decision whether or not to register a marriage by the registrar is the provision of a service within the meaning of Section 5 of Bermuda's Human Rights Act. And because the Human Rights Act precludes discrimination on the grounds of sexual orientation, it was held that refusing to register a same-sex marriage constituted the provision of a service in a discriminatory manner, contrary to the Human Rights Act. So by judicial decision-making, it was ruled that same-sex marriages had to be registered in Bermuda. That was then followed in July 2017 by a general election, and the Progressive Labour Party, which was then in opposition, its platform or election manifesto was to put forward a compromise. And the compromise had two elements. It would have the proposal of civil unions, domestic partnerships, being legalized as between same-sex couples, but continuing to preserve the term marriage for unions between parties of the opposite sex. And that, I won't turn it up, but the electoral platform is quoted in the Attorney General's evidence in the electronic bundle at page 1223 in Ms. Ajar's witness statement at paragraph 8. As I say, we don't need to go to it, but those are the two elements of the proposed compromise: domestic partnerships for same-sex couples, marriage for opposite-sex couples. The Progressive Labour Party won the election, and there was then extensive consultation, which is again described in the evidence. So we could just look very briefly at page 1224, just to see the steps that were taken. Paragraph 10, again, of Ms. Ajar's statement: prior to and during the drafting process, we sought and received legal advice from the Attorney General's chambers. In drafting the bill, there were several adaptations with necessary modifications from the Marriage Act 44, Matrimonial Causes Act 74, Maritime Marriage Act 99, New Zealand's Civil Union Act, and the United Kingdom's Civil Partnership Act. A table of derivations is attached. If you would like to look at that, I wasn't going to take you to it, but it is instructive just to see the derivations, but from the UK and from New Zealand. The page reference is page 902. As I say, I won't go to that. But what may be useful is to see the attitude of one of the parties that is now before you, which is out Bermuda at the time. And I would ask you just to turn up page 906, which is a letter from out Bermuda, November the 15th, 2017. And I commend all of it to you, but if I could just pick up the third paragraph on page 906, where they say, in the lead up to the referendum on marriage, equality and civil unions last year, out Bermuda openly recognized that while marriage equality is a noble goal, the majority of our country's citizens were not yet ready to embrace it. At the time, we took the view that it was in the best interests of our country for us to propose a compromise on the issue. And on that basis, we advocated for civil unions. That compromise was roundly and aggressively rejected by those opposing marriage equality. They then go on to say that marriage equality remains a noble goal, and that there are, they believe, signs that support for it is increasing. But if one could just turn from the bottom of the page, where it's talking about the younger cohort increasing the apparent support, and just go over to the very top of page 907, they say this: be that as it may, we are where we are. Out Bermuda recognizes that the compromise it advocated for in 2016 is still in the best interests of all of Bermuda. So that puts very clearly in context the legal question that is being put in front of you, because one of the litigants in front of you is asking the court, Privy Council, to reverse the outcome which it advocated as a matter of policy in the interests of all Bermuda at the time. So very starkly, a litigant is trying to achieve through the courts what it could not achieve through the ballot box, and indeed did not advocate through the ballot box. Now, we'll come, as I say, to the legal significance of that kind of point, but I did want to start the advocacy by making clear that that is the context in which this litigation is being brought. So with that, the bill is debated. We've got extensive Hansard extracts in the bundles, and there has been some reference to them. The quality and the earnestness of the debate is admirable, and leaving aside pepper and heart, if you are simply curious to read the debates, it is illuminating. But I wasn't proposing to do anything other than to record the fact that as a matter of chronology, the bill, the Domestic Partnerships Bill, passed through both houses of the Bermudian Parliament in December 2017, received governor's assent in February 2018, and it is worth, before leaving the evidence, just mentioning that the evidence given on behalf of the Attorney General was not subject to cross-examination, and Ms. Azar, on behalf of the Attorney General, made clear, and I would just mention, I don't need to go to them, but pages 889 and 893, 1225, she makes quite clear that the minister was not motivated by any religious considerations in putting forward the bill, and was not influenced by Preserve Marriage Bermuda, which is one of the pressure groups which you will have seen reference to. So as a matter of evidence, what you have at the end of the day is these, and what I would just ask you to keep in mind when we're getting into the legal argument is just these points. The first is that Bermuda is the first of the Commonwealth island jurisdictions, if one can call it that. It's obviously not in the Caribbean, but it has a certain amount of historical connection with Caribbean jurisdiction. Bermuda is the first of the Commonwealth Islands jurisdictions to have introduced legal recognition for same-sex unions. The second point is that the impugned elements of the Domestic Partnerships Act are part of a package. They are not, it was not a single issue piece of legislation to reverse the outcome in Godwin and Roche. The impugned provisions are part of a package. The third point, as you will have seen, is that that was a package produced after a considerable period of public debate. And self-evidently, fourthly, it represents a compromise. It is not, as some of my learned friends' authorities would lead you to believe, an expression of the tyranny of the majority. As with many compromises, both sides are a bit annoyed about certain elements. And as lawyers often say, when they have compromised litigation, that is usually quite a good sign. And the fifth point, as I've already mentioned, is that one of the interest groups that supported that compromise then is now trying to reverse, essentially, the outcome and excise one element of the compromise through the judicial process. With that brief introduction, could I then emphasize a couple of points as to what this litigation is not about? Most importantly, it is not about discrimination on the grounds of sexual orientation, and it can't be. And the reason is very simple, and it's structural. Bermuda had got its Human Rights Act about 18 years before the United Kingdom did. Bermuda's Human Rights Act precludes discrimination on the grounds of sexual orientation. Bermuda's Human Rights Act contains a primacy clause saying that it takes priority over other legislation unless that other legislation expressly provides that it overrides the Human Rights Act. So the Human Rights Act has a rather attenuated primacy clause, which is, we don't need to go to it, but for your note, it is section 30B, capital B, of the Human Rights Act, and it's on page 1552. So the Human Rights Act expressly precludes discrimination on the grounds of sexual orientation, but it expressly enables other legislation to provide inconsistently with that. The Domestic Partnerships Act does exactly that. Section 8 of the Domestic Partnerships Act, which is at page 1532, Section 48 of the Domestic Partnerships Act makes the kind of express provision that is permitted by Section 30B of the Human Rights Act. Section 48(1) of the Domestic Partnerships Act says the following provisions have effect, notwithstanding anything to the contrary in the Human Rights Act. And D is Section 53 of the Domestic Partnerships Act. And Section 53 is a few pages later at page 1535, and it is the principal operative provision which is sought to be challenged in these proceedings. Section 53 provides, notwithstanding anything in the Human Rights Act, any other provision of law, or the judgment of the Supreme Court in Godwin and de Roche, a marriage is void, unless the parties are respectively male, female. So in that regard, the Domestic Partnerships Act did what the Human Rights Act enables it to do, which is to say that the discrimination on grounds of sexual orientation is off the table as a ground for potential challenge to anything in Section 53 and the other provisions of Section 48 of the Domestic Partnership Act. So the only ground for alleging discrimination in this case is what the Constitution protects, which is Section 12 of the Constitution, which does not include a ban on discrimination on the grounds of sexual orientation. It's a much more constrained provision. We'll look at it right at the end. It'll take the least amount of time. It's the third of the three issues, but it's very short because it's very clear, and it does not, in our submission, preclude what has happened in this case. So I wanted to emphasize, as I say at the very beginning, that this is not a case about discrimination. You will see many cases from other jurisdictions that deal with discrimination, and what we would not wish is for your minds to be in any way infected by the thinking that goes into that kind of decision making, because that is simply not in play here. The second point that I just wanted to emphasize at the very outset is that this case is not about the content of the substantive legal rights that are bestowed on those who enter into domestic partnerships. There is no complaint that the legal consequences of entering into a domestic partnership under Bermudian law are in any sense unfairly less than the substantive legal rights which attach to marriage. That is a point we made in our written case at paragraph 8. And my learned friend's written case does not take issue with that assertion. He effectively admits and avoids, and he says not, oh, well, no, there are substantive differences under Bermudian law. That's not his case. What he says is that by running this argument, the Attorney General misunderstands the significance of the complaint, and that his clients consider it demeaning not to have marriage available to them. But in making that point, with the greatest respect, all my learned friend is actually doing is adding a rhetorical flourish to our point. Our point is that this case is about a label. It's not about substantive legal rights. It's about whether the word marriage should be applied to same-sex unions. And we would urge you to keep that very clearly in mind, particularly when we get to questions of proportionality right at the end of the arguments under Section 8. The only other tail-end point my learned friend adds in relation to that is that he says that the laws of some other jurisdictions, certain states in the United States of America, for example, attribute different rights to married couples from those they attribute to those in civil partnerships. And that may be true, but the constitutionality of Bermudian legislation cannot depend upon legislative choices in other jurisdictions as to whether they choose to discriminate between married couples on the one hand and civil partners on the other. That's not a relevant test for assessing the constitutionality of Bermudian legislation. So with those introductory points, could we then turn to the first of the three main headings, the religious purpose rule, short. And we need to start very clearly by establishing what the debate is actually about. And what I'd like to do is just to start by looking at how this issue was addressed and decided in the Court of Appeal. So if we could get up, we have the Court of Appeal judgment in two places, but for electronic purposes, I think it would be most convenient if we just looked at it in the Bermuda bundle. It starts at page 421. And what I want to do just in a few minutes is to clarify how the religious purpose rule was treated by the Court of Appeal in its judgment, as just as a matter of, in a sense, classification. What were the terms by reference to which the debate was being had and the issue was decided? If we just look at paragraph 1 on page 422, you'll see 4 lines down, the court says this appeal is about section 53 of the DPA, whether it was passed for a religious purpose, point 1, and whether it offends section 8.2 or section 12.3 of the Constitution. Chief Justice Coaley held that it was not passed wholly or mainly for a religious purpose, but that it does offend both sections 8 and 12 and granted declarations accordingly. The Attorney General for Bermuda has appealed his decision on sections 8 and 12, and the respondents have sought to uphold his decision to strike down section 53 on other grounds, including that it was passed for a religious purpose. It is, in our submission, entirely clear from that introduction and from a few other paragraphs I'll just walk you through, that the Court of Appeal was discussing and decided the question of whether or not the legislation was unconstitutional on the grounds that it was passed for a religious purpose, entirely separately and without reference to section 8. The religious purpose rule was being considered as a freestanding rule, not as an aspect of section 8, but quite separately from section 8. Now, I entirely accept that the reason why this appears to have happened is that there wasn't sufficient argument about the point in the Court of Appeal. The basis on which the Court of Appeal proceeded, as we'll see, if we go forward to paragraph 6, page 424, just in terms of structure, you will see that the first section is headed religious purpose. And it is not until one gets significantly further in the judgment, we'll get to it in a moment, but you will see we don't get to section 8 of the Constitution until page 27 of the judgment. There is no consideration of section 8 in relation to this religious purpose rule. And the reason it would seem, it emerges from the bottom of page 425, paragraph 7, where after making a few remarks about the parliamentary sovereignty principle in the United Kingdom, in the last 4 lines of page 425, you'll see the court says, in Bermuda, Parliament's freedom to legislate is constrained to the extent that it must not pass legislation that is inconsistent with the fundamental rights and freedoms of the Constitution, point 1, nor, because it has a secular constitution, can it pass laws wholly or mainly for a religious purpose, point 2. This is common ground and beyond dispute. The arbiter of whether the legislature has crossed the permitted threshold is necessarily the judiciary. There's sometimes, as in this case, no easy matter to determine. And then if one just flips on to see the structure of the judgment, page 441, having considered and decided whether or not the relevant provisions of the Domestic Partnerships Act were passed for a religious purpose, that section finishes with para 42, and the court decides it was passed for a religious purpose, and then it goes on to consider the Constitution, starting at paragraph 43, under the heading the Constitution. And then if you go on to page 447, having made some introductory remarks about the Constitution, the court then considers section 8. So it's entirely clear that the religious purpose rule was discussed and decided in the Court of Appeal entirely separately from the question of whether or not there was a breach of section 8 of the Constitution. And that is reflected in the order that the Court of Appeal made, which is at page 460. And you'll see that paragraph 1, at the very bottom of page 460, gives 2 reasons for holding, 2 separate reasons for holding that section 53 is invalid. A, because it was passed mainly for a religious purpose, and B, because it contravenes section 8. And it is clearly not saying it was passed mainly for a religious purpose and therefore contravenes section 8, because there is no therefore in the judgment at all. And that becomes clearer again from paragraph 2 of the order. The appeal is dismissed, sorry, at the top of page 461. The appeal is dismissed, the decision and order of the Chief Justice is upheld in relation to section 8, but not his decision on section 12. The Chief Justice's decision is varied in relation to the purpose of section 53, in accordance with the court's finding on the primary purpose of that provision. And if I may say so, the clear distinction between the religious purpose rule and the question whether or not there has been a violation of section 8 of the Constitution is also reflected in the way that the issues are defined in the statement of facts and issues for this board. I don't need to ask you to turn them up, but paragraphs 15, 16 and 17 of the statement of facts and issues at page 1240 in the electronic bundle make it perfectly clear that we are asking 2 questions about the religious purpose rule and 1 question about whether or not section 8 is violated. And they are treated entirely distinctly, because that is how it was understood, certainly on this side. The Court of Appeal had actually decided the point. Now, as I say, this is in some senses not an unqualified criticism of the Court of Appeal, because it appears to have been common ground that that was the correct approach, but the Attorney General has thought further about it. And it would seem that my learned friend has too, because my learned friend is not, in fact, seeking to uphold the Court of Appeal's judgment according to its tenor. If we look briefly at his written case, paragraph 2, page 1301. Paragraph 2, you'll say the respondents submit that the revocation provisions are inconsistent with the Bermuda Constitution. 1, they breach freedom of conscience and religion contrary to Section 8 because they have a religious purpose. So my learned friend's argument seeks to shoehorn the religious purpose principle as an aspect into Section 8, as an aspect of freedom of conscience. And that becomes more explicit in paragraph 17, if we look briefly at page 1308. Where at the very bottom of 1308, he says, he's got the heading, the revocation provisions breach Section 8 by having a religious primary purpose. So the case that is being put on behalf of the respondents, as I say, is not, in fact, to defend the Court of Appeal judgment according to its tenor, which treated the existence of a religious purpose as a freestanding, i.e. a rule outside the confines of the Constitution. And he is running the argument that the religious purpose rule, the rule that the Parliament of Bermuda cannot pass any legislation if its purpose is wholly or primarily religious, is an aspect of Section 8. Now that makes it helpful and clear what the battle lines are, and it also means that it is unnecessary to spend much time on those parts of our written case which dealt with the legislative authority of the Bermuda Parliament. But it still does persist to frame our discussion about whether the religious purpose rule does form part of Section 8 of the Constitution, just to remind ourselves of the legislative authority of the Bermuda Parliament. So could we just look at the Bermuda Constitution very briefly? Section 34 of the Constitution is at page 1495. And Section 34 provides, subject to the provisions of the Constitution, the legislature may make laws for the peace, order, and good government of Bermuda. Now, we've quoted in our written case, I won't go back to it, we've quoted Lord Hoffman in the case of Barcools number 2, who, after a review of a considerable amount of earlier colonial litigation, observes that the formula peace, order, and good government was a formula used again and again and again in the constitutions of what were once called colonies, and it has never been interpreted as wording of limitation. That wording is the formula that is used to confer plenary legislative power. So the Parliament of Bermuda has plenary legislative power, subject only, under Section 34, to the provisions of the Constitution. So in order to satisfy you that the relevant provisions of the Domestic Partnerships Act are unconstitutional by virtue of Section 8, my learned friend has to satisfy you that it is the provisions of Section 8 that somehow preclude any legislation being passed, primarily or wholly for a religious purpose. And if we look at Section 8, which is at page 1474, one then immediately sees the challenge that my learned friend faces. Because Section 8 is quite clearly drafted in terms of an effects-based test. We just look at, if you're on page 1474, Section 8.1, except with his consent, no person shall be hindered in the enjoyment of his freedom of conscience, and for the purposes of this section, the said freedom includes freedom of thought and of religion, freedom to change his religion or belief, and freedom, either alone or in community with others, and both in public or in private, to manifest and propagate his religion or belief in worship, teaching, practice, and observance. Section 8 is clearly broken if somebody is hindered in the enjoyment of those rights. The only question it poses is, has there been a hindrance of the enjoyment of protected rights? Now, we can entirely accept as an abstract proposition that legislation which happens to have, if it does, a religious purpose, is perfectly capable of hindering the enjoyment of somebody's religious or other beliefs. But my learned friend's argument must go conceptually much further. He has to satisfy you that merely because legislation has a religious purpose, whatever that means, we'll come to that, therefore it hinders necessarily somebody's enjoyment of their freedom of conscience. And in our submission, that is simply not what Section 8 says, and it's not how Section 8 works. And while you are considering the arguments that you will have heard by the end of tomorrow, you will obviously be spending a considerable amount of your time considering the interpretation of the Constitution. And the approach to that, as you will have seen from the parties' written cases, is that you are encouraged by what Lord Wilberforce said in Fisher and the Minister of Home Affairs to give constitutional rights a generous interpretation, and no doubt you will abide by that. But we would also remind you of what Lord Hoffman said in Matadine and Quantu. If I could invite your attention to that, which is at page 3340. The facts of the case do not particularly matter. It was a claim that arose in relation to the Constitution of Mauritius. The passage that we would urge your Ladships and your Lordships to bear in mind is at page 3350, where his Lordship said this, just above letter C. Their Lordships consider that this fundamental question is whether Section 3 properly construed in the light of the principle of democracy stated in Section 1 and all other material considerations expresses a general justiciable principle of equality. It is perhaps worth emphasising that the question is one of construction of the language of the section. It has often been said in passages in previous opinions of the Board, too familiar to need citation, that constitutions are not construed like commercial documents. This is because every utterance must be construed in its proper context. taking into account the historical background and the purpose for which the utterance was made. The context and the purpose of a commercial contract is very different from that of a constitution. The background of a constitution is an attempt at a particular moment in history to lay down an enduring scheme of government in accordance with certain moral and political values. Interpretation must take these purposes into account. Furthermore, the concepts used in a constitution are often very different from those used in commercial documents. They may expressly state moral and political principles to which the judges are required to give effect in accordance with their own conscientiously held views of what such principles entail. It is, however, a mistake to suppose that these considerations release judges from the task of interpreting the statutory language and enable them to give free rein to whatever they consider should have been the moral and political views of the framers of the Constitution. What the interpretation of commercial documents and constitutions have in common is that in each case, the court is concerned with the meaning of the language which has been used. As Justice Kentridge said, Justice Repeal Kentridge said in the South African case, if the language used by the lawgiver is ignored in favour of a general resort to values, the resort is not to interpretation, but divination. Excuse me. And his lordship returned to that theme 6 years later in the case of Boyce. I could just remind you of that, which is on page 2027. This is one of the many mandatory death penalty cases. The decision starts at 2027. I just wanted to take you to a short passage on page 2051. Paragraph 59, where his lordship says, the living instrument principle has its reasons, its logic, and its limitations. It is not a magic ingredient which can be stirred into a jurisprudential pot, together with international obligations, generous constructions, and other such phrases, sprinkled with a cherished aphorism or two, and brewed up into a potion which will make the Constitution mean something which it obviously does not. If that provokes accusations of literalism, originalism, and similar heresies, their lordships must bear them as best they can. So, my lords, my ladies, what we do urge on you is that you are going to be engaged on a process of construction of a provision, Section 8 of this Constitution, which protects people against having their freedom of conscience hindered. And that, as we submit, is an effects-based test. It is not a question of simply divining a religious purpose in the legislation and making the logical leap, therefore, there has been a breach of Section 8. That is simply not how the legislation works. And that, in a sense, is our main point against my learned friend's argument under this whole section of the appeal, because with the greatest respect, his argument simply does not make that logical connection between the assertion that a religious purpose necessarily leads to a hindrance of the rights protected under Section 8. There is simply a hole at the heart of his argument. He refers to lots of case law, and we'll go through some of that in a moment to see whether it says what he wants it to say and if it should be adopted in Bermuda. But essentially, the argument that we would wish to press on you in relation to Section 8 is that you are there to interpret what it means, and in our submission, its language is perfectly clear and its effect is perfectly clear. And it is an effects-based provision, and simply to strike down legislation on the sole ground that the purpose of the legislation is said to be religious is not interpreting Section 8. It is to create an entirely judge-made principle outside the terms of the Constitution. And that would be, as we've just seen from Section 34 of the Constitution, that would involve limiting the power of the plenary legislative power of the Parliament, otherwise than by reference to the provisions of the Constitution. If we could just see how my learned friend puts the point in paragraph 17 of his case. We were there a moment ago. If we could just go back to page 1308. Very bottom of 1308, paragraph 17, he says the constitutionality of a legislative provision depends on its purpose as well as its effects. And he refers to Big M Drug Mart and Lord Bingham in Reyes. He says the respondents submit that the revocation provisions are unconstitutional because they have a religious primary purpose which breaches the right to freedom of conscience and religion contrary to Section 8. Now, his reliance there on Big M Drug Mart and Reyes is in our submission flawed essentially for three reasons. The first, in a sense, is just the most obvious but worth stating, which is that neither of those cases has anything to say about the Constitution of Bermuda. The second is that Reyes, the Privy Council case my learned friend relies on, is not authority for the proposition which he seeks to get from it. So his proposition is that it's a breach of the right to freedom of conscience to enact legislation for a religious purpose. Reyes, if we could just look at briefly, it's page 4967. So another mandatory death penalty case. And it is quite true that Big M Drug Mart is mentioned along with a clutch of other cases from other jurisdictions at page 4967. Paragraph 26. But it is perfectly apparent from reading this paragraph that Lord Bingham was not citing Big M Drug Mart in support of the proposition from which, on which my learned friend would wish to rely. My learned friend's proposition is that a religious purpose renders a piece of legislation unconstitutional without regard to its effects because it necessarily hinders somebody's religious conscience, freedom to enjoy their religious conscience. Paragraph 26 of Reyes has absolutely nothing to do with that principle at all. It is talking at the highest level of generality with the approach to be taken to the interpretation of constitutions. And in doing so, it mentions, among others, the Fisher case that we've seen and Matadine and Pontu, which we have also seen. So I'm not going to take up time reading it, but we get generous and purposive interpretation, and we also get the reminder, echoing what was said by Lord Hoffman in Matadine and in Boyce, where Lord Bingham says the court has no license to read its own predilections and moral values into the Constitution. It is required to consider the substance of the fundamental right at issue and ensure contemporary protection of that right in the light of evolving standards of decency that mark the progress of a maturing society. There is absolutely no reference at all to the principle on which my learned friend seeks to rely. Paragraph 26 of Reyes is, as I say, expressed at a high level of generality as to the approach to be taken to construing constitutional rights. So, whilst it is entirely true, and tribute to who owes our industry, noted that Big M Drug Mart happens to be mentioned by Lord Bingham in that passage. It is not dealing with anything remotely connected with a religious purpose rule or specifically to do with the protection of freedom of conscience under any constitution. So that's the second reason why this line of argument doesn't work. The third reason why Malone and Friends' argument doesn't work is that when we do actually turn to Big M Drug Mart, which is in a sense the sort of high watermark of his argument, it does not, on our submission, support his proposition, or if it is taken to support that proposition, it should certainly not be adopted as the law of Bermuda. The Canadian judgments, I don't know if any of your ladyships or lordships have yet started to try dipping into any of the Canadian Supreme Court judgments. They are admirable in their comprehensive approach. None of them, I think, is less than 100 pages. Some of them reach 200. So I'm not going to spend the time trying to get to grips with the detail of all of it, because we simply do not have the time. But can I just start with Big M Drug Mart in order to give you a very quick overview of its structure and a very quick headline description, what we say you do actually get from it, in light of the other important case, which is the Saguenay case, which Malone Friend also seeks to rely on, the Mouvement Ligue Québécois and Saguenay. So it's these two cases, Big M Drug Mart and Saguenay, are the two Canadian cases which Malone and Friend seeks to get most support from. Big M Drug Mart was a Sunday trading case. If we can get it up, it starts at page 4761. And the legislation that was challenged in this case was called the Lord's Day Act. So it was not exactly hiding its purpose. And the question was whether an enforced day of rest on the Lord's Day constituted an unconstitutional interference with the Canadian equivalent of our Section 8, the freedom of conscience. And just to, in a sense, give you some orienteering through this detailed judgment, the report, as I say, it starts on 4761. And just so that you can understand what the issues were and where they come in, if you go to page 4777, you'll see at the very bottom of the page the constitutional questions. So that just gives you the issues that the court is going to address. We then get over the page at 4778, standing and jurisdiction, which you can ignore. That is a sort of Canadian law, so to speak, on who can complain about what. One then goes on to page 4782, section 5, characterization of the Lord's Day Act. And you will see that what the court does, it leaps straight into a long and quite largely historical analysis of whether the purpose of the legislation is religious or not. It is an incidental point. I don't want to take up too much time because the details and the ins and outs of Canadian constitutional law don't necessarily matter. But you will see from this, and also more clearly from the Saguenay case, that at least one reason why the courts had to examine the purpose of the legislation is that there is, as in many federal arrangements, a separation of legislative functions between the province, which is entitled to make legislation in relation to civil rights and property, and the federal legislator, which is entitled to make criminal law. So the question whether or not the purpose of the Lord's Day Act was criminal was religious or not, was relevant to whether or not it fell within the legislative jurisdiction, so to speak, of the federal legislator, or was legislation that the local, the provincial legislator was entitled to make in managing civil rights and property. But we get that section 5 characterization, as I say, the judgment just jumps straight into considering purpose. We then go on to page 4797. And this is where the court discusses whether or not it is enough to strike down legislation because its purpose is religious. And I entirely accept that there are passages in here which do suggest that that is the outcome, but they are, with respect, pretty jumbled and in some respects circular. And what is in fact being said becomes more apparent a little later, and also from Saguenay. If we just pause on page 4797, having considered the history and the case law in the previous section of the judgment and come to the conclusion that the purpose of the Lord's Day Act was to enforce religious compliance with a particular Christian sectarian belief. We then get in section 6, purpose and effect of legislation. And the court says, a finding that the Lord's Day Act has a secular purpose is, on the authorities, simply not possible. Its religious purpose in compelling sabbatical observance has been long established and consistently maintained in the courts of this country. Now, he is espousing, I accept on the face of it, a principle that a religious purpose is enough to strike down legislation as being a violation of freedom of conscience. But he is in fact repeatedly jumbling purpose with effect, because he is saying that the religious purpose in compelling sabbatical observance, it is the effect of the purpose that makes it offensive to the freedom of religious conscience. And he then goes on to record the Attorney General's argument, conceding characterization by this religious purpose. He contends, however, that it's not the purpose, but the effects of the act which are relevant. And he refers to an early case which was more sympathetic to that view. And then the judge says, I cannot agree. In my view, both purpose and effect are relevant in determining constitutionality. Either an unconstitutional purpose or an unconstitutional effect can invalidate legislation. All legislation is animated by an object the legislature intends to achieve. This object is realized through the impact produced by the operation of the application of the legislation. Purpose and effect, respectively, in the sense of the legislation's object and its ultimate impact, are clearly linked, if not indivisible. Intended and actual effects have often been looked at for guidance in assessing the legislature's object and thus its validity. Now, I'm not going to spend too long unpicking all that because we don't really have to conduct a detailed critique of this, but our essential points are that that is very jumbled thinking. It actually begs the question he is attempting to prove by simply saying, and thus its validity at the end. It provides no rationalization for saying that legislation is unconstitutional purely because it has a religious purpose without regard to its effects. And when it is in fact discussing the point, it is so jumbling purpose with effect that at least on one reading, what it is saying is that the effects are potentially objectionable if their purpose is religious. And one certainly gets that if one then moves on to the next section, which is section 7, which starts at 4802. So we've had purpose as opposed to effect. Suppose section 7 deals rather more comprehensively with the question of whether or not there has been a hindrance with the enjoyment of freedom of conscience. It's headed freedom of religion. And again, we don't have time to read much, but if I could just draw your attention on page 4803, right in the middle of the page, to the extent that it binds all to a sectarian Christian ideal, the Lord's Day Act works a form of coercion inimical to the spirit of the Charter and the dignity of all non-Christians. In proclaiming the standards of the Christian faith, the Act creates a climate hostile to and gives the appearance of discrimination against non-Christian Canadians. So that is the finding of interference. And if one goes on within the same section, page 4813, 4813, just between letters E and F, it is the contention of the respondent that the Lord's Day Act violates freedom of conscience and religion by coercing the observance of the religious institution of the Christian Sabbath. And that point is then picked up again 3 pages later, 4816. You just look at letter H, right at the end of the paragraph between G and H. In my view, compulsion is nevertheless what it amounts to. So in the section dealing with has there been interference or hindrance in the language of the Bermuda Constitution, yes, there is coercion, and it's a religiously motivated coercion, which is therefore a violation of the citizens' freedom of conscience. One then gets finally section 8 over the page, 4817. Which is headed section 1 of the Charter. Section 1 of the Charter is in essentially the point of entry for justification. The rights that are set down may be interfered with for a public interest in a proportionate manner, to put it very, very crudely. So section 8 is essentially dealing with justification. And what is significant here is if one goes to page 4821, one sees the paragraph between D and F. Sorry, that actually, no, sorry, that's in classification. The sorry, I do apologise. I should have taken you to 4818. I do apologise. 4818 between D and G. In terms of justification, the debate it will be familiar to European eyes. One has to identify an objective, a legitimate objective to pursue, and it has to be pursued in a proportionate manner. Having reached the conclusion that the purpose of the legislation is religious coercion, that then factors into the conclusion that it can't be justified because seeking to enforce religious compliance with a particular sectarian view is not a legitimate objective. So it is at that stage in context of justification that we can entirely see that the purpose of the legislation can come into play. And one sees that at page 4818 in the middle of the page. At the outset, it should be noted that not every government interest or policy objective is entitled to Section 1 consideration. Principles will have to be developed for recognising which government objectives are of sufficient importance to warrant overriding a constitutionally protected right or freedom. Once a sufficiently significant government interest is recognised, then it must be decided if the means chosen to achieve this interest are reasonable, a form of proportionality test. And what the court then goes on to decide with this page and the next is that because it has been decided that the purpose is religious, that is not a legitimate objective for the government to pursue when it comes to justification. So we can entirely see that that context is where religious purpose may have a role to play. But in short, what we say is either that Big M Drug Mart does not, as a matter of Canadian law, stand as authority for the bare proposition which Melanchthon seeks to get from it, which is that you only have to look at purpose, not effect. And if you can establish religious purpose, that's enough. The legislation is unconstitutional. We say you do not get that from Big M Drug Mart as a matter of Canadian law. Alternatively, if you read the case as espousing that view, we would urge you not to adopt that as the law of Bermuda for a number of the principles and practical reasons that we will go through. Now, there's one other case. I'm conscious of the time, but there's just one other closely related case. If it would be acceptable just to deal with Saguenay as well, that will then wrap up this thread. Saguenay is Mouvement Laïque Québécois, and Saguenay is page 3535. Now, this was a different situation. This was not a complaint about legislation. This was a complaint about the practice adopted by a local council, which said prayers, Christian prayers, before its council meetings. And the complainant, well, the individual complainant was a committed atheist and objected to the saying of prayers. And the question was whether or not the saying of prayers, his attendance at the prayers was not, in fact, compulsory. There was a pause between prayer and council meeting, so he could have absented himself. But nevertheless, he brought the complaint. If we could just, again, very quickly go through the judgment, because it makes clear in our submission that the approach that we are urging on drug in relation to the analysis of what Big M Drug Mart decides is very clearly reflected in Saguenay. I just wanted to wrap that point up before the mid-morning break. So if we could start at page 3546, you'll see, again, just to give you the structure of the judgment, 3546 is where the judgment begins. We then go on to the next page, 3547. Paragraph 4 helpfully just gives you a very brief headline of the ratio. I would allow the appeal through the recitation of the prayer issued during the municipal council's public meetings. The respondents are consciously adhering to certain religious beliefs to the exclusion of all others. In so doing, they are breaching the state's duty of neutrality. The resulting discriminatory interference with Mr. Simoneau's freedom is supported by the evidence the tribunal accepted. We then go on to 3554. That gives you at paragraph 3 the issues that the court engages with. And then again, there are various issues that you don't need to trouble yourselves with. There's questions about the standard of review between the tribunal and the court, which cover a number of the following pages. We can go on to 3568. Where the court comes to deal with the prayer. And again, just to see a summary of the ratio on that page 3568, paragraph 64, you'll see the judge says, in my opinion, the appellant's position must prevail. Sponsorship of one religious tradition by the state in breach of its duty of neutrality amounts to discrimination against other such traditions. And over the page, the court deals with what it describes as neutrality of the state as regards freedom of conscience and religion. And over the page again, 3570, para 69, having set out some material from Big M Drug Mart, what this court gets from Big M Drug Mart in para 69, this passage shows that freedom of conscience and religion protects the right to entertain beliefs, to declare them openly and to manifest them, while at the same time guaranteeing that no person can be compelled to adhere directly or indirectly to a particular religion or to act in a manner contrary to his or her beliefs. So the interpretation that is being given there is to an effects-based analysis of what the protection of freedom of conscience is all about. It's about saving people from being compelled to adhere to a particular belief or practice. Very quickly then, the last couple of paragraphs, page 3572, paragraph 72, as Justice Labelle noted, the evolution of Canadian society has given rise to a concept of neutrality according to which the state must not interfere in religion and beliefs. The state must instead remain neutral in this regard. This neutrality requires that the state neither favour nor hinder any particular belief, and the same holds true for non-belief. And then at the top of the next page, 3573, when the state adheres to a belief, it is not merely expressing an opinion on the subject, it is creating a hierarchy of beliefs and casting doubt on the value of those it does not share. It is also ranking the individuals who hold such beliefs. Over 3574, the last two critical paragraphs, para 76, page 3574, para 76. When all is said and done, the state's duty to protect every person's freedom of conscience and religion means that it may not use its powers in such a way as to promote the participation of certain believers or non-believers in public life to the detriment of others. And finally, page 3576, which wraps up the whole argument. Para 83, in a case like this, in which a complaint of discrimination based on religion concerns a state practice, the alleged breach of the duty of neutrality must be established by proving that the state is professing, adopting, or favouring one belief to the exclusion of all others, and that the exclusion has resulted in interference with the complainant's freedom of conscience and religion. First, because of the duty of religious neutrality with which it is required to comply, the state may not profess, adopt, or favour one belief to the exclusion of others. Goes on to expand that. And para 85, second, the state practice must have the effect of interfering with the individual's freedom of conscience and religion, that is, impeding the individual's ability to act in accordance with his or her beliefs. On the other hand, it is not the case that every burden on an individual's freedom, even the most insignificant, constitutes discriminatory interference. My ladies, my lords, I'll pause there. That wraps up the Canadian line of authority, and as you will see from those last passages that I've emphasised, our analysis of them is that they do not stand as authority for a proposition in Canadian law that legislation can be struck down for breach of freedom of conscience, purely because of its purpose. You have to look at the effects as well. If that's a convenient moment for the...
Yes, certainly, Mr. Crowe. We'll adjourn now and resume in 5 minutes' time. Thank you. I think we're ready to resume, Mr. Crowe.
Thank you. The last case that the Court of Appeal relied on, and my learned friend relies on, is the English Court of Appeal decision in Macfarlane and Relate Avon. That is in the authority bundle. It's at page 3361. Your ladyships and your lordships may recall from what we've said about this in our written case that we say you really do not get any assistance from it at all. It was a funny little case in more ways than one. It was an application for permission to appeal to the Court of Appeal against a decision of the Employment Appeal Tribunal. The factual situation was that the applicant was a counsellor who, for religious reasons, refused to give psychosexual counselling to same-sex couples. And the employer insisted that their employees should provide counselling services on a non-discriminatory basis, and he was dismissed, and he brought a complaint to the Employment Tribunal, which dismissed it. He appealed to the Employment Appeal Tribunal, which dismissed it, and he then applied to the Court of Appeal for permission to appeal. None of that would have the slightest relevance or interest to this board, were it not for the peculiarity that a former Archbishop of Canterbury made a witness statement in support of the application, suggesting that the English courts were unsympathetic to Christianity, and he invited a special panel of 5 judges to be appointed to hear the application, comprising members who had a demonstrable sympathy to religious issues. And Lord Justice Laws took the opportunity of effectively wagging a judicial finger at the former Archbishop of Canterbury and explaining that that's not how the courts work. Having given that explanation of what was being said, I don't propose to read passages from it to you, because our responses to it are very short. They are, first of all, that self-evidently the Court of Appeal was saying absolutely nothing about the Constitution of Bermuda. Secondly, insofar as Lord Justice Laws in passing made reference to the idea that it was unprincipled to make legislation for a religious purpose, plainly he was speaking obiter, because there was absolutely no question of the validity of any legislation being discussed in front of him. And thirdly, because it is self-evidently the case that legislation is often passed for a religious purpose. We've included in our written case numerous examples of legislation which is passed for a religious purpose. Sikhs wearing turbans, not having to wear crash helmets. Special dispensations being made in order to permit kosher or halal butchering. Numerous examples are given. So one really doesn't get any assistance from Macfarlane that is relevant. And the fact that it was referred to again in a subsequent case, my learned friend has picked up that Macfarlane was subsequently referred to in Johns and Derby County, which, just for your reference, I won't go to it, but it's page 2892. The reason Macfarlane was cited again is that the same solicitors instructed the same counsel to deliver to the court what was described as the same extravagant rhetoric to which they had been treated in the case of Macfarlane. And so the court delivered again the admonition from Lord Justice Laws, reminding the advocate as much as anybody what the function of the court was. With respect, the court, this board is not going to get anything from those remarks of Lord Justice Laws in that case. So where we get to essentially on the case law in support of my learned friend's religious purpose rule is that our submission is that the case law simply doesn't support it. So in just to sort of pause and see where we got to, our two submissions essentially are that Section 8, the wording of Section 8 could not be more clear. As a matter of construction, what it is providing is an effects-based test. The question in every case is, has there been hindrance of the enjoyment of a person's freedom of conscience? And the second point we have made is that there is no case law that should lead this board to reach a different conclusion in relation to the proper interpretation of Section 8. With those remarks, my lord, my ladies, could I just go back and make sure we know where I've got to in our written case? If I could invite your attention to page 1261. And on page 1261, you'll see that we reach a heading, Other Reasons for Dismissing Any Religious Purpose Rule. So having covered the point of construction and having looked at the Canadian case law on Macfarlane, the other reasons that we suggest the board should take into account in declining to adopt a religious purpose rule. We pick up paragraph 35. We say that it's unnecessary and hence unprincipled. It is unnecessary to invent this principle because Section 8 is the defined protection for freedom of conscience. It would be unprincipled simply to create a judicial rule that essentially rewrites that protection. Para 36 of our written case, we make the point I just made orally a moment ago, that there is self-evidently a considerable amount of legislation, certainly in England, which has a religious purpose. Now, my learned friend's way of dealing with that, I won't invite you to go to it, but perhaps just for your note, in his case, written case at paragraph 26.1, which is at page 1312, he says that there is a difference between legislation which is designed to protect the right to conscience and religion and legislation which is designed to advance a particular religious belief. Well, that, with the greatest respect, is an extremely flimsy, fragile basis on which to try operating this religious purpose rule. The difference between protecting and advancing a religious belief very likely to be in the eye of the person whose religious belief is either being supposedly advanced or supposedly protected, and the eye of those who hold a different or no religious belief at all. One man's advancement is another man's attack. In any event, the language in which my learned friend seeks to recharacterize this rule it is simply too imprecise to form the basis of a legal test. He refers to legislation which is designed to protect or designed to advance. And that looks like it is suggesting some sort of subjective test for determining whether or not this religious purpose rule it is going to be violated. And that, in our submission, would be a heretical way forward. But ultimately, the end, if, however, one adopts a properly objective approach, then again, one would actually just be flipping back into an effects-based test, whether or not the legislation does have the effect of hindering a religious belief or hindering an agnostic belief or an atheistic belief. So in our submission, the response that has been offered to our point that there is multiple legislation which has a religious purpose, it is simply not a satisfactory one. So for that accumulation of reasons, just flipping over, I was going to track our written case for a little while now, just to give some structure to what we're saying. Top of page 1263. Essentially, we hit the conclusion in relation to the question whether or not there is a religious purpose rule as part of Section 8. And we say neither as a matter of construction, nor as a matter of case law, nor as a matter of a principle, should there be any such rule. We then go on in Section B4 to deal with, well, what would the religious purpose rule look like if you were against us and you took the view that such a rule should be introduced. And we spend a bit of time discussing what on our principal argument are contingent hypothetical points as to what the scope of the rule would be. So I don't want to spend too long on any of those, but I just want to remind you of those points, because to some extent, the fact that these questions would arise if a religious purpose rule were to be concocted, the fact that these questions would arise in our submission feed back into your assessment of whether it's a good idea to try conjuring a religious purpose rule in the first place. So what we do in Section B4 of our written case is to go through the various points that would arise were a religious purpose rule to be devised. And the first question at the top of page 1264 is to ask, well, what kind of religious purpose is going to be permissible and what kind of religious purpose isn't? So we have the kosher, the halal, the crash helmet exceptions. Those clearly are unobjectionable. And they are, we would suggest, unobjectionable because they do not coerce compliance by anybody with a religious practice. They are, therefore, on an effects-based test, unobjectionable because they do not hinder the enjoyment by anybody of their religious freedoms. So by having to apply one's mind to the question, well, how do you devise a rule that saves the crash helmet, the kosher, the halal examples, it simply drives you back to the observation we have already made, which is that you don't need this religious purpose rule because Section 8 of the Constitution already provides an entirely coherent definition of the freedom that needs to be protected. It is a freedom against hindrance of religious belief, practice, expression, and so on. The next point we deal with, Section B4.3, we ask whose purpose it needs to be ascertained. If you are going to espouse a religious purpose, test for the validity of for the validity of legislation, the question then arises: well, whose purpose are you looking at? Now, I think in substance there is actually agreement between my learned friend and I that the answer is you're going to be looking at the collective purpose of Parliament. The reason we raise this is that in our submission, going through in paragraph 41 of our cases we do, you go through the Court of Appeal's judgment, that is not the approach it is taking. It is looking and quoting substantially from external pressure groups in particular Preserve Marriage Bermuda, quoting their will, so to speak, as somehow informing what Parliament's purpose should be interpreted as being. And in our submission, that is an extremely dangerous route to go down. I mean, it is difficult enough to resort to Hansard, things that are said in Parliament, in order to identify collectively Parliament's view, because we all know that the case law is full of warnings, warnings to the courts, against taking words said by MPs or even ministers as reflecting the will of Parliament or the intention of Parliament, because somebody may well vote in favour of a particular bill, notwithstanding what a minister has said, not because of what a minister has said. And so there are many warnings in the case law. And my learned friend's case mentions Wilson and First County Trust. We may go to that briefly in a moment. But that is a particularly clear demonstration of the warnings against that. And even worse, we would submit, is doing what the Court of Appeal does, which is not even to be looking at what is said in Hansard, but to be looking at what is said by pressure groups outside Parliament. So don't need to spend long on that, as I say, in the sense that ultimately the landing point that one would get to if this were a doctrine that you wished to espouse is that the purpose must be the purpose of Parliament, and it should be the purpose of Parliament viewed objectively from the words enacted, construed in their relevant context. We'll come back to that in a moment. And then over the page 1265, we come to an important point. Is it the sole purpose, the primary purpose, or an ancillary purpose that defeats the legislation? Does the challenger have to prove that the sole purpose of the legislation was religious, or is it sufficient if it was only the primary purpose? Again, one can approach this as a matter of principle and as a matter of case law. As a matter of principle, if one is, in a sense, judicially adding to Section 8, we would invite you to do so on an absolutely minimalist basis and only strike down legislation that has a solely religious purpose. Because if, as I say, the four walls of Section 8 do not seem to comprehend, to embrace a purpose-based test at all. If you were at all attracted by a purpose-based test, we would invite you to give it the narrowest possible confines. If one looks at it on a case law basis, one sees we've picked up in paragraph 47 of our case on page 1266, the McFarlane case that we were talking about a moment ago. Lord Justice Laws there talks about positions held purely on religious grounds. And it may also be worth mentioning, one gets slightly mixed messages on this point from the Canadian cases, but it may be worth just noting in Big M Drug Mart at page 4804. Justice Dixon does say, it may not be necessary to go back to it, but at 4804 between E and F, Justice Dixon says, if I am a Jew or a Sabbatarian or a Muslim, the practice of my religion at least implies my right to work on a Sunday if I wish. It seems to me that any law purely religious in purpose, which denies me that right, must surely infringe my religious freedom. So he appears there to be putting the test on the basis of striking down legislation if it has a purely religious purpose.
Mr. Crowe, a point you didn't draw attention to, but which may be of interest, is in the respondent's case, in the passage you took us to on page 1312, they submit, as they put it, that there is an important distinction between, on the one hand, legislation designed to protect the right to conscience and religion, and on the other hand, legislation designed to advance a particular religious belief. And the examples that you give in your case, the former kind, and this case is of the latter kind. Now, the point that's interesting is that their focus is on advancing a particular religious belief. So they would accept as constitutional, I take it, your example, if they don't quarrel with any of your examples, and one of them is the grant of charitable status to organizations for the advancement of religion. Now, that would offend, I would have thought, against the Canadian approach. But it doesn't offend against theirs because they're not saying that there's a ban, under a constitutional ban, on anything which advances religion, but rather anything designed to advance a particular religious belief.
Yes.
The interesting question might be, well, where do you get that from the Constitution? The Saginaw has a very long passage quoting from Justice LaBelle in an earlier case, explaining how in Canada it's explicable that the Charter has come to be interpreted in the way it is because of Canadian history.
Yeah.
And the influence, for example, of the French tradition of l'état laïque. And so they have taken quite a strict line. It's being suggested effectively by other respondents that it's a somewhat less strict line in Bermuda. But what isn't explained is what's the basis for drawing that distinction?
Absolutely, and my lord, if I could say, I mean, the fact that one can have this debate in order to try defining the scope of this supposed religious purpose rule demonstrates that we are having, in a sense, a sort of legislative drafting debate. How do you define this supposed right? Because it is not by reference to a process of interpretation. It is a process of essentially judicial legislation. The fact that we're trying to identify the boundaries and that there could be different answers given demonstrates that it is essentially a legislative policy choice. The other point, just your lordship helpfully mentioned the importance of Canadian history. The other point I didn't mention, but in paragraph, I think it's 74 of Saginaw, reference is made to the fact that the Canadian Constitution itself reflects that. I think in section 24 or 27 of the Canadian Constitution, there is an express exhortation to interpret the Constitution in light of the multicultural history of Canada. And it is precisely for that kind of reason that it is dangerous, apart from anything else, to try drawing too much assistance from the Canadian cases in relation to the Bermudian Constitution. I was then going to turn back to our case at page 1266, where it's a short, but it's an important point. The next question would be, if there is to be this rule, do you apply it section by section or subsection, subclause by subclause, or do you take a view on the Act as a whole? Obviously, our submission is that the judge at first instance got it right, and that the view should be taken on the Act as a whole. You can approach this by two different routes. You can either conjure a general principled response, or you could give a sort of case-by-case answer. Our submission in either event is that this Act should be interpreted, the purpose of this Act should be interpreted by reference to the whole Act. As a matter of general principle, we say that because, exactly like questions of interpretation, statutory interpretation can only be properly undertaken by reference to interpreting provisions in their wider context. And the most relevant wider context is the Act as a whole. It is from the Act as a whole that one therefore derives the purpose of the legislation. That has particular force, that approach has particular force on the facts of this case, because we know that this legislation was a compromise. So different bits of it have plainly, as in any compromise, different bits of it have been included with the intention of achieving a consensus between competing interests. So if you simply lift out one provision and view its purpose in isolation, you are doing violence to the compromised nature of the whole. So we would, as I say, we would offer two answers. One is the general principled answer. You should always view the question about whether or not a particular provision has a religious purpose by reference to the purpose of the Act as a whole. But a fortiori, you should do that in relation to legislation which is avowedly a compromise, because, as I say, you would be doing violence to the compromised nature of the whole by salami slicing and examining the particular purpose of one provision. Just moving on then quickly, page 1267, the next issue we address is how the court should set about identifying the religious purpose. And this is largely a bit of a wrangle about whether we are in pure pepper and heart territory or whether we are in the rather more expansive world of Wilson and First County Trust, which says that you can look at Hansard in order to identify the mischief to which an act is addressed and the question of proportionality under the Human Rights Act, or here the Constitution. Lord, the argument that we had advanced in our written case was being advanced at a time when we thought we were addressing a religious purpose rule independently from the Constitution. The terms within which we are now having the debate are that the religious purpose rule is being advanced as an aspect of Section 8 of the Constitution, and that therefore we are looking at the question of, well, how does the court identify the purpose of the legislation for the purpose of assessing whether or not it is human rights compliant or not? That being the context, we are minded to accept, Lord, that the Wilson and First County Trust approach would be the correct one. But could we just remind ourselves very briefly of what Wilson and First County Trust did actually say? It starts at page 5361. I don't know if it's one your lordships and your lordships have had to look at all recently. It was had a remarkable procedural history. I think by the time it got to the House of Lords, none of the parties were represented. We had nothing but interveners and amicus curiae appearing. I think there were 5 speaking parts, none of whom was either the plaintiff or the defendant. It turned on a rather arcane point as to whether or not a particular provision in the Consumer Credit Act was or was not an unlawful interference with peaceful enjoyment of possessions, because its effect was that a lender was unable to recover either the principal or the interest on the loan if the amount of interest had been incorrectly recorded on the consumer credit agreement. So it was simply a provision that had a pretty draconian effect.
In answer to your question, some of us have been looking at this case recently very closely in connection with a very similar issue under the Human Rights Act, but others of us have not. So you should take it fully, I think.
Well, I'm very grateful. The reason why the question of whether or not resort to Hansard should be allowed, I think, arose because it would seem to have been one of those occasions where a minister might have turned over 2 pages at once when he was presenting the bill to Parliament, and gave what, on one view, was a rather garbled version of the effect of this particular provision. And the point was taken that Parliament didn't know what it was doing when it enacted this bit of legislation. Mr. Jonathan Sumption, QC, was instructed on behalf of the House authorities to address the court among the Attorney General and various other luminaries. But it gave focus to the question, well, when and for what reason should you be looking at Hansard? And I just wanted to draw your attention to two very short passages, one at 5388, where Lord Nichols says at paragraph 66, I expect that occasions when resort to Hansard is necessary as part of the statutory compatibility exercise will seldom arise. The present case is not such an occasion. Should such an occasion arise, the courts must be careful not to treat the ministerial or other statement as indicative of the objective intention of Parliament, nor should the courts give a ministerial statement, whether made inside or outside Parliament, determinative weight. It should not be supposed that members necessarily agreed with the minister's reasoning or his conclusion. And Lord Hobhouse made remarks to similar effect. If one just looks quickly at page 5409, paragraph 139, it's the very short sentence between G and H. As Mr. Sumption pointed out in his submissions, it is a fundamental error of principle to confuse what a minister or a parliamentarian may have said or said he intended with the will and intention of Parliament itself. So, Lord, we would simply remind this board with respect of those words of warning. But I think in principle there isn't a significant difference between us. For what it is worth, and if this is of significance in any other case, there's also a short extract from Sullivan on the construction of statutes, which is in fact one of my learned friend's authorities, but it does include a useful section on this at page 5663. Paragraphs, I won't read them out, but I just draw your attention to paragraphs 9.28, 9.29, and 9.30. 9.30 perhaps particularly relevant in our context, where the learned author say it's important to distinguish the purposes of the legislature from the motives of individual participants in the legislative process. Such motives may range from altruism or a desire to advance public welfare through partisan political considerations to a self-interested desire to benefit oneself or one's friends. Generally speaking, the motives or participants in the legislative process are irrelevant to interpretation. What matters is the intentions that can be imputed to the legislature as a corporate entity. And in our submission, that is helpful, and with respect, we would submit correct proposition. And its relevance here is obviously that there may well have been individuals who were animated by a religious conviction to oppose same-sex marriage. But looking at the words, the motives of the individuals who may have been advocating for that does not answer the question as to what the collective purpose of Parliament was in enacting a package of legislation, which happens to include a clarification that same-sex marriage was not to be lawfully recognized. So,
am I right in thinking that this is a Canadian textbook on statutory interpretation?
Yes, you're quite right, my lord.
Yeah.
So that is all we have on identifying the true purpose of the legislation. Can we then move back in my case to page 1268, where we deal with the slightly smaller focus issue, which is assuming against me that you consider that there is a religious purpose rule. The fact is that the judge at first instance, decided that the purpose of the legislation was mixed and therefore not predominantly religious. And the Court of Appeal took a different view. Now, what we say in this section of our case is simply this. First of all, the proposition, which I think is uncontentious, that the judge's decision as to the purpose of the legislation was a question of fact, not an analysis of law. Secondly, therefore, the rules of the game in the Court of Appeal were the Court of Appeal had no business interfering with his finding of fact unless either there was no evidence to support his conclusion, which is not contested, it's not suggested by the other side. There plainly was plenty of evidence. We've listed it if you want to remind yourself. Or the Court of Appeal could interfere if the judge at first instance had made an error of law or principle. It's on that basis that my learned friend seeks to defend the Court of Appeal interfering with the judge's analysis. And this turns on the point that I've already addressed you on, which is what is the correct approach to identifying the purpose? Is it a provision by provision approach or not? And the Court of Appeal said that the judge erred in assessing the purpose by reference to the legislation as a whole, and he should have salami sliced. And they took the view that the primary purpose of Section 53 and the cognate provisions was religious. And in our submission, that is a wrong approach, really on two levels. First, we submit that the Court of Appeal was wrong in law to say that the judge at first instance was wrong in law. We say the judge's approach at first instance was entirely right for the reasons we've already offered, that you assess the purpose of the legislation as a whole, a fortiori where it's a compromise. Secondly, but in any event, we say that the Court of Appeal's approach in deciding for itself on the facts that the purpose of the Section 53 and the other related provisions, the Court of Appeal's approach was simply wrong on the material, because it did exactly what Wilson and First County Trust and Sullivan warn against, which is to assume that the collective will of Parliament, in passing, even if we're just considering the purpose of Section 53, the Court of Appeal wrongly assumes that the collective purpose of Parliament was to be identified by looking at extra parliamentary pressure group statements and observations made by individual parliamentarians. And that's what they do throughout paragraphs, it's sort of paragraphs 36 to 42 of the Court of Appeal judgment. And our submission is that is, even if it were right to consider the purpose of the provision on its own, on the evidence, they took a wrong approach. And so we submit that the short answer to the question we raised in the heading at B6 is no, the Court of Appeal had no business to interfere with the Chief Justice's assessment. Having given the introduction we did, my lady and my lords, that brings us, I think, usefully to the end of that first and main issue. So I think we've got to page 1272. And
you haven't. I mean, you may be content just to rest on what you've put in writing, but you do make quite an important point, perhaps, on page 1270, challenging the assumption that because marriage is a sacrament, it follows that the protection of marriage necessarily has a religious purpose.
yes,
You point out that it, socially and culturally, it's a central institution, even for those who don't regard it in religious terms.
I'm grateful for your lordship reminding me of that. As it happens, I was going to, yes, we certainly do stand by what we say there. I was in fact going to revisit that issue in relation to the justification argument under Section 8.
Yeah.
So if it's convenient,
yes, certainly.
I'll get back to it there. So just to wrap up on the religious purpose rule, the argument essentially, stripped to its essentials, is very straightforward, that the legislative authority of the Parliament is plenary. Its legislative authority is limited only by provisions of the Constitution. The relevant provision is Section 8. Section 8 is an effects-based provision. It does not allow the court to strike down legislation simply because of its purpose without regard to its effect. So we then move on to the second main topic, which is whether there is, in the circumstances of this case, any hindrance with the rights protected by Section 8. So far as this part of the argument is concerned, I hope I do not need to emphasize, but I will, in any event, underline that there is absolutely no question about the sincerity with which the respondents' beliefs are held. And there is absolutely no question about the importance to the respondents of the beliefs that they hold. Those are not being impugned or belittled in any sense at all. The only questions the attorney wishes to address you on are questions of law as to what is the scope of protection provided by Section 8. What beliefs are protected? Secondly, is there any hindrance in this case with the enjoyment of those beliefs? And thirdly, if we're allowed to argue it, can any such hindrance be justified? So
on that last issue, our inclination is to hear what you have to say, de bene esse, and we can decide if we need to whether the issue of justification is one that you can properly be allowed to argue.
I'm very grateful. I think both sides. I'm grateful for that indication, my Lord. I think substantially both sides had certainly hoped, if not anticipated, that might be the way forward, because my learned friend, as you will see, has included an annex to his written case, providing a top-line answer on justification in any event. The argument here is, as you appreciate, entirely by reference to Section 8 of the Constitution. What we do in the first part of the written case is to deal at some length with the question of the decision in Godwin and de Roche. Just to remind ourselves, the first instance court in Godwin and de Roche in May 2017 had decided that the provision by the registrar of the function of registering or not registering marriages was a service within the meaning of Section 5 of the Bermudian Human Rights Act. The Bermudian Human Rights Act provides that, since 2013, provides that there cannot be discrimination on the grounds of sexual orientation in relation to the provision of services. And so the decision in Godwin and Roche was that there was discrimination which was disallowed by the Human Rights Act, and that therefore same-sex marriage was, in a sense, permitted or required by the Human Rights Act. That decision was not appealed, and you will have seen, if your ladyships and your lordships have looked at the first instance judgment in our case, that the judge starts with an perhaps unnecessary, enthusiastic endorsement of the decision in Godwin. And we simply wanted to, we're not trying to turn this into an appeal against the decision in Godwin, because that's not what is in front of you. But we just wanted to put in place if nothing else, a sort of judicial question mark as to whether the courts should proceed on the assumed basis that Godwin was necessarily decided. It was decided on a relatively narrow point as to what is or isn't a service under Section 5 of the Bermudian Human Rights Act. And the reason that the case could, and one might say should have gone the other way, is that if one looks, it may just be convenient without arguing the point, just to understand the point. One looks at the Human Rights Act, just a couple of provisions. So page 1545. We have Section 2 interpretation in this Act, and then if we go over the page, subsection 2, for the purposes of this Act, a person shall be deemed to discriminate against another person, A, if he treats him less favourably than he treats or would treat other persons generally, or refuses or deliberately omits to enter into any contract or arrangement with him on the like terms and like circumstances, as in the case of other persons generally, or deliberately treats him differently to other persons because, 2, of his sexual orientation. So that's the definition of discrimination on the grounds of sexual orientation. And then if one goes to page 1549, one sees Section 5. The way the Bermudian Human Rights Act operates, as you will appreciate, it's not anything like an exact template against our Human Rights Act. It provides for, in a sense, activity-specific protections against discrimination and so on. So in Section 5, it says, no person shall discriminate against any other person due to age or in any of the ways set out in Section 2.2, which we've just seen, in the supply of any goods, facilities, or services, whether on payment or otherwise. So that is why the question in, I don't know if we have lost Lord Sales, but my screen has just gone blank.
Yes, the little triangle suggests that, here he's back.
All right. Right. Yeah. Sorry, I was here all the time. I didn't lose contact, at least orally.
Thank you. Thank you. So as I say, it's because Section 5 says what it says that the question in Godwin and Roach turned on whether or not the grant or refusal of registration of a marriage by the registrar was a service, and the argument on that was conducted by reference to Section 31 of the Act, which is at page 1552. And Section 31 provides that this Act applies to an act done by a person in the course of service of the Crown. If we just flip over A and B, as it applies to an act done by a private person. Now, those words, as it applies to an act done by a private person, appeared in 1976 English discrimination legislation, which was considered in the House of Lords in a case called Amin. This is covered in our case, but I'll just give you the top line so that you understand the scope of the debate. Those are almost identical words, I think, as it applies to an act done by a private person, were considered by the House of Lords in an immigration case called Amin in 1986, I think, 83. And what the House of Lords said was that what those words connote is that the legislation applies to the Crown insofar as the Crown is doing something that a private person could do. An entry clearance officer was not doing something that a private person could do, and the argument on behalf of the government in relation to Godwin was that registering or not registering marriages was not something a private person could do, and therefore it wasn't a service within Section 5. Now, that argument did not find favour in Godwin, but since then, in a different case called Tavares, which is in our case, I won't take it up, but just so I've explained the context. Since Godwin was decided, the Court of Appeal in Bermuda has said in Tavares that it prefers the view in Amin that what those words mean is that the Human Rights Act applies to the Crown insofar as a person in the service of the Crown is doing something that an ordinary person could do, a private person could do. So if the Court of Appeal's preferred view in Tavares had been expressed before Godwin had been decided, Godwin would have been decided differently from how it was. So all I get from that is a rather long roundabout way of just inviting the board, with respect, not to start its approach to the whole question under Section 8 on the assumed basis that Godwin was correctly decided as a matter of Bermudian law. As I say, it is no part of my case to invite you to rule that Godwin was wrongly decided. But Tavares having said what it said, one might well start with the view that Godwin would in fact have been decided differently if it had been decided after Tavares. So we just want to sort of park that in order, in a sense, to start with a kind of a neutral position under the Human Rights Act, but to emphasise more importantly that whatever the Human Rights Act might produce by way of an answer to the question, is there or is there not discrimination based on sexual orientation, is a complete irrelevance in this case, because the Human Rights Act isn't in play. As we saw right at the beginning, the Human Rights Act has this oddly attenuated primacy provision in it, which allows other ordinary legislation to displace it. And the Domestic Partnerships Act expressly displaces the protections provided by the Human Rights Act. So the only question for this board is whether or not there is a breach of the constitutional human rights, not whether there's a breach of any Human Rights Act human rights. And the two are significantly different. So with those introductory words, I think I have covered what are pages 1273 through to 1276. And we have already looked at the wording of Section 8, which we have on 1276, and we've already seen Matadine and Pointu and Boyce. So what I wanted them to do is to pick up the argument at the first really crucial stages of the analysis under Section 8, which start at page 1277 of the bundle, Section C4 of our case. And the first issue we address there is whose beliefs are relevant, and there's no need to add anything to what we have said in writing there in paragraphs 85 and 86. But what we do want to spend some time on are sections C4.3 and C4.4. What is the content of the belief? And most importantly, are they beliefs that are protected by Section 8? Now, the content of the beliefs are helpfully summarised in the first instance judgment, which we mentioned there, but also in identical terms in the Court of Appeal judgment. And it may just be convenient to add or to refer to that since that is directly the judgment they're appealing from. And there is no argument about this. My learned friend doesn't take issue with this summary. So could we just remind ourselves of paragraph 57 of the Court of Appeal judgment, which is page 449. And you'll see there that the Court of Appeal adopts essentially the Chief Justice's summary of the protected beliefs with 4 bullet points. A religious belief in marriage as an institution recognised by law, which same-sex couples ought to be able to participate in, held by persons who would like to so marry. Second, a non-religious belief in marriage as an institution recognised by law, which same-sex couples ought to be able to participate in, held by persons who would like to so marry. A religious or non-religious belief in marriage as an institution recognised by law, which same-sex couples ought to be able to participate in, not held by persons who would like to marry, e.g. friends and family or other same-sex married couples who would like to see future same-sex marriages. And finally, a religious belief in marriage as an institution recognised by law, which same-sex couples ought to be able to participate in, held by ministers of religion and or churches who would like to conduct such marriages. Now, what we seek to emphasise when analysing whether or not this clutch of beliefs falls within the protection of Section 8 is that every one of them contains, and rightly contains, the words marriage as an institution recognised by law. The belief that is being relied upon is a belief as to what the content of the law of Bermuda ought to have. Now, that in our submission is an extremely important feature when one then turns to analyse whether that is a belief that Section 8 protects. If we can go back to Section 8, which is at page 1474, just remind ourselves, 8.1, except with his consent, no person shall be hindered in the enjoyment of his freedom of conscience. And for the purposes of this section, the said freedom includes freedom of thought and of religion, freedom to change his religion or belief, and freedom either alone or in community with others, and both in public or in private, to manifest and propagate his religion or belief in worship, teaching, practice, and observance. Now, just in order to narrow down the number of things we need to think about, the legislation that has been challenged does not, on any view, hinder what people believe. It doesn't stop you believing in same-sex marriage. It doesn't stop you changing your mind about it. So we are in the territory only of having to consider whether what has been hindered is that aspect of the enjoyment of freedom of conscience, which is captured by the words alone or in community with others, and both in public or in private, to manifest and propagate his religion or belief in worship, teaching, practice, and observance. Now, obviously, all the elements within Section 8.1 need to be interpreted in light of all the other elements. And if I could just, in the few minutes before the luncheon break, go through and just identify why the cumulative effect of section 8.1 is, in our submission, very clearly to provide that the beliefs on which these respondents seek to rely simply do not fall within the scope of protection. It's not because they're not important beliefs. It's not because they are trivial. That is no part of the Attorney General's case. There's not some sort of hierarchy of importance. And we do not seek to trivialize or belittle the seriousness and the importance of these beliefs to these respondents. But that isn't the test. Section 8 doesn't protect important beliefs. What it does, and the umbrella term, is it protects the enjoyment of freedom of conscience. That is the umbrella term which informs the elements that are then defined as being included within that. So we ask the board to give value to what freedom of conscience means in this particular context. What beliefs are captured will also be informed by the explanation of the scope of protection which is extended to manifesting those beliefs. You are protected in relation to manifesting and propagating religion, belief, in worship, teaching, practice, and observance. Our submission in relation to that quartet is that what they are dealing with only is a class of acts which are personal, autonomous, and unilateral. I manifest my religious belief if I give up chocolate at Easter, if I don't eat meat on Friday, if I honour Ramadan, if I go home from work before sundown on Friday and do no work on Saturday. That is me manifesting my belief, and it is an act, an autonomous individual act by the individual acting unilaterally. The difference between that and what these respondents are seeking to rely on is that marriage is not a unilateral act by an individual. Marriage is an interaction between the state and the individual by means of the civil law. Marriage is a legal status. And the short point under this part of the argument is that we submit that Section 8 protects the individual in relation to his own autonomous actions, but it does not confer on the individual a right to demand from the state recognition of a legal status which the individual would like to have. That is simply not worship, teaching, practice, or observance, or any other form of manifestation of a belief. My ladies, my lords, I was going to go to one case, oddly, from Hong Kong, simply because it happens to quote, we've got Bellinger in the House of Lords, the Supreme Court. There's just an interesting quote apropos this point, and it's very, very short. So if I could slot it in. It's a very, very short quote because it quotes from Bellinger in the Court of Appeal. that just captures some of this point. If you would be good enough to turn up page 3494.
Just before we do, it may, just while we have section 8 in front of us, it may be worth just noting that political opinions are protected by sections 9 and 10,
Yes.
insofar as they guarantee freedom of expression and freedom to hold opinions, to receive and impart ideas, and under 10, to assemble.
Yes, indeed. I'm grateful, and I will mention that apropos of Lee and Ash's Bakery. So yeah, so very briefly, the question of same-sex marriage, as you may be aware, has come up in many different jurisdictions. It's had an outing in Hong Kong. As it happens, it failed there. That doesn't prove anything. But what I did want just to draw to your attention, if you look at page 3497, it's just interesting, as I say, apropos the line of the argument that we were just urging on you, that paragraph 7 of the judgment, the Hong Kong court says, marriage has been said to be perhaps the most important and sensitive of human relationships. It has also been said that the legal recognition of marriage is a matter of status and is not for the spouses alone to decide. It affects society and is a question of public policy. Status is not conferred only by a person upon himself. It has to be recognized by society. Marriage has deep-rooted social and cultural connotations which may differ largely from one society to another, and thus the status acquired by marriage varies according to the laws of different places. But that quotation, as you see, footnote 3, Bellinger in the Court of Appeal, captures something of what we are urging on you as the difference between the right that is protected by Section 8 being a right to believe something and to express that belief in teaching, practice, observance, all being matters of unilateral action by the individual expressing his conscience, his or her conscience, on the one hand, and on the other hand, the legal recognition of marriage. And that is why I emphasize those words in each of those 4 bullet points. What is being relied on by these respondents is their belief as to what the law ought to provide to them. If that's a convenient moment, I've reached a natural break in the argument, my lord. My lady. I'm sorry, my lady, I think you're on mute.
That's it. Perhaps I could just ask a brief question. We know from case law in the United Kingdom that people do not always want to enter into the status of marriage and prefer civil partnership. Can it not be also that they have deeply held views that they should not enter into civil partnerships, but should enter into marriage because of the deep-rooted social and cultural connotations, or for whatever reason? And could that not be a conscientiously held belief by a person who wishes to enter into marriage but cannot do so because of a prohibition in the law?
My lady, that is, I think, a part of the respondent's case. And our answer to it is that that is absolutely a firmly held, honestly held, deeply held, important belief. For many people, I am perfectly prepared to accept. But that doesn't bring it within Section 8, because what Section 8 does is to protect your ability to hold that belief. The legislation doesn't interfere with your ability to hold that belief. What is protected by the legislation only, though, in relation to action, is manifesting your belief. And that, in our submission, involves a protection provided to the individual as to what the individual can do. And it's not a right to demand of the state recognition of a status, because that is not an individual manifesting his belief, it's an individual demanding the bestowal of a benefit from the state.
But if it is a belief, a conscientiously held belief, then manifestation is the ability to enter into the legal union represented by marriage.
My lady, that I'm sure my Lord Panic has written down, if it wasn't already part of his notes. That is his case. The answer I have given, I think probably won't improve by repetition.
No, I just wanted to put it to you. I'm not expressing a view. I just wanted to know what you were saying about that. Thank you.
Is it over simple to say that on your argument, Section 8 doesn't impose positive obligations on the state?
I'm not. Can I just pause before answering whether it confers any positive obligations? I wouldn't wish off the cuff to give a absolutely hard-edged answer to that.
Another aspect of it, but the way you've put it, is that it's really concerned with the individual conscience, and therefore not with social constructs, if you like, which can't be a matter simply of individual conscience.
Exactly.
Well, is that a convenient point at which to adjourn?
Thank you, Miller.
Well, in that case, I see we're some way past 1 o'clock. We'll resume at 2:05.